Hello, it's good to be back with you. We've already talked in prior lectures about the introduction, question, answer, and facts section of a memorandum. We're in the process now of talking about the analysis section. Our last lecture discussed the first two parts of the IRAC mnemonic, the I or issue and the R or rule. This lecture discusses the third part of the mnemonic, the A of IRAC, the application. As usual, I have a short definitional slide, and you might want to pause the video now to read it. When you're ready, let's talk about the portion I've highlighted in red, how the facts apply to the relevant laws. First, note the word apply. You will hear some people saying that the A in IRAC stands for analysis, but the better view is that it stands for application. This is especially true in our class, where we're using the heading analysis for the part of the memo that comes after the facts section. We don't want to confuse the entire analysis with the A of IRAC. Second, note that what we're doing in the A of IRAC is applying facts to law. You can see from the wording that this activity, this application, necessarily requires a discussion of both facts and law. So don't just discuss the facts of your client's case in the A of IRAC. If you do, your reader will have to connect the dots between what you said in the R of IRAC and these facts you're giving him or her in the A of IRAC, maybe even physically flipping pages back and forth between R and A. Let's take a look at an example. You want to start your A of IRAC with a broad topic sentence that begins with the road sign here. Here is a road sign because it's a word we use to signal our readers, usually other lawyers, that we're now entering the A of IRAC, where we're going to start talking about our client's case. Don't use here anywhere except as the first word of the first sentence of A. If you use it elsewhere, it loses its power as a road sign. Note too that here is a counterbalance to the word there, which we use in the second part of our rule examples in the R of IRAC. Now, beyond the topic sentence for the A of IRAC, you're on your own in terms of how you structure it. I don't have any recipes for the A like I do for the R. But remember the math comic we saw in class. You can't have a miracle happen somewhere in the middle of your proof. You must walk the reader from the issue to the conclusion one step at a time. You must plug your facts into the legal framework and show the reader how things come out. Think of the legal framework as a mathematical formula and the facts of your case as the variables or numbers. Plug the numbers into the formula and the formula spits out an answer. But continuing with the math metaphor here, don't do the calculations in your head. Write them all down for the reader. Okay, let's take a look at some guidelines. How do we do this? How do we walk the reader from the issue to the conclusion, connecting all of the dots? The first thing we do is go back to our high school English. We compare and contrast the legal authorities to the facts of our case. Now we're lawyers, so we have to use fancier words. We use the words analogize and distinguish, which essentially just mean compare and contrast. We always need to be careful to explain why the legal framework produces a certain answer, so consider using the word because to force yourself as a writer to get your reasoning down. Consider additionally using sequential enumeration as an organizational device. This is when we've used the words first, second, third, and so forth to structure part of our paper. For example, suppose we had a client, Mr. Smith, who was involved in an age discrimination case, and we were writing the A of IRAC. Suppose further that we've discussed a precedential case, the Jones case, in the R of IRAC. We might start the A of IRAC with a topic sentence that says, here, there are several similarities to the Jones case. Then we might go on to say, first, using sequential enumeration, Mr. Smith and Mr. Jones both worked for their employers for many years, 30 and 25 years respectively. Second, Mr. Smith and Mr. Jones were both exemplary employees, as evidenced by their annual reviews. Finally, Mr. Smith and Mr. Jones were both fired within 6 months of turning 65. Finally, remember to mention your authorities in the A of IRAC because you don't want the A of IRAC to be a fact dump. This is one thing I'll be looking for when grading. But note that I'm using the word mention purposely. I don't want you to cite your authorities in the A of IRAC. As explained more fully in the workbook, the only place I want citations in the entire memo is in the R of IRAC. I realize this idea of mentioning but not citing authorities could be unclear at this point in the semester. After all, you're only a few weeks into law school and you haven't yet written a memorandum. So here are some examples. As a review, applying facts to law necessarily means you must have both facts and law in the A of IRAC. You want to avoid a fact dump. In other words, the A needs to be more than just the facts of your case. You need at least principles or rules of law, if not facts from precedential cases. So, as I've said, you want to mention your cases and other authorities, but as I've also said, you don't want to cite them. Cites are only for the R of IRAC. And that brings me to a comment about redundancies. The memo format has built-in redundancies. Just as we state facts in the facts section and then reiterate them in the analysis section, we also state rules in R and revisit them in A. This is okay. It meets your reader's expectations. Your reader expects and wants this redundancy. It's a good thing. Remember the analogy to a mystery movie. The viewer wants all the clues along the way, and when the big reveal happens at the end, she doesn't want any surprises. So with that review, let's get on with the topic at hand. There are 2 ways to correctly compare your case to the precedential cases. 2 ways to correctly mention the authorities in the text of the A of IRAC. The first way is to use generalized terminology that applies both to your case and to the precedential case. Suppose Peter Kaplan, the artist who created the photograph on the left, has sued your client, the company that created the photograph on the right, accusing your client of infringing his copyright. You're writing a memo on whether Kaplan will prevail. In the R of IRAC, you discuss a precedential case, Kish, where the plaintiff copyrighted the image on the left and the defendant later created the image on the right. You explain in the R of IRAC that the Kish court held in favor of the defendant there was no copyright infringement. In reaching that holding, the court explained that poses cannot be copyrighted. So the fact that the 2 subjects' poses are so similar, both are sitting down, holding a musical instrument and leaning against a padded bench, is not proof of infringement. The plaintiff wanted to protect a pose, and the court said he couldn't. When you get to the A of IRAC, you need to use a word like pose that applies to both cases. Something like this. In other words, you would not want to say something like here, comma, like Kish, comma, Mr. Kaplan is trying to protect a businessman's stance. First, you'd be comparing a whole case, Kish, to a person, Kaplan. You need to compare a person to a person as in the example. Kaplan in the example is compared to the plaintiff in Kish. Second, if you use the phraseology the businessman's stance, the only case involving a businessman's stance is your case. This phrasing doesn't bring Kish in at all. Here's another example from Fernandez-Caro, a case that appears in the workbook's appendices. You wouldn't want to say something like Mr. Fernandez-Caro, like Roshan, was beaten about the head and shoulders, waterboarded, and electrocuted. Again, you'd be comparing a whole case, Roshan, to a person, Mr. Fernandez-Caro. You need to say something like I did here, something like the defendant in Roshan, or even Mr. Roshan, provided you've nicknamed the defendant Mr. Roshan. And again, you'd be providing a fact dump. Your client, Fernandez-Caro, was beaten, waterboarded, and electrocuted, but those same things didn't happen in the precedential Roshan case. You've got to use language that could apply in both cases, as I did here, physically invasive, painful, and dangerous. My final example is a hypothetical case involving a radical feminist theater group out of Boulder, possibly now defunct, called Vox Feminista. At one of Vox's shows, they aired a fake iPhone commercial, a parody or a spoof, poking fun at all of us for being obsessed with cell phones. Vox used an actual iPhone ad as the basis for its parody, but made some important changes. I asked my students to analyze whether Vox had infringed Apple's copyright in the ad. In the R of IRAC, many students discussed Blanche, a case where the defendant won on a claim of copyright infringement because his secondary work was so different from the original copyrighted work in terms of aesthetics and meaning. When the students came back to Blanche in the A of IRAC and compared their case to Blanche, they had to use generalized phrasing like differs sharply that could apply to both cases. The words color, orientation, and size are also general enough to apply to both cases, but you wouldn't want to say something like bright colors unless bright could apply to both cases. So to reiterate, the first way to mention authorities without citing them in the A of IRAC is to use terminology that's generalized enough to apply to both cases. The second way is to actually make very precise fact-to-fact comparisons using your specific facts in your case and specific facts in the precedential case. Again, you always want to compare a person to a person, an artwork to an artwork, a document to a document, and so forth. You don't want to compare a person, for instance, to a whole entire case. In this example, I compare Mr. Minot, a person, to the defendant in Smith, another person. I also compare the skeleton, an object, to a gun and camera, more objects. I compare an office to a car, a car with its doors closed and where people are in private. So I'm comparing people to people, objects to objects, places to places. And I'm making very specific connections between particular facts in my case and particular facts in the precedential case. In this second example, again, I'm making precise fact-to-fact comparisons between my case and the precedential case. First, I'm comparing a party, Vox, to another party, the defendant in Blanche. Second, I'm comparing a very specific fact, the intent to discourage cell phone use in Vox, to another specific fact, the intent to critique mass media in Blanche. Here's a final example of how to make fact-to-fact comparisons very precisely between the facts of your client's case and the facts of precedential cases. It comes from the model memo. You can see that in this A of IRAC, I'm making a very precise fact-to-fact comparison between a fact from my case, circled in blue, the act of opening the duffel bag, and a fact from the precedential case, also circled in blue, the disclosure of the gun and camera. So the first fact, the act, is from your case, and the other fact, the disclosure of the gun and camera, is from the precedential case. Let's go on and look at other comparisons I've made in here. I have compared a fact from Smith, where the court said that the act was basically the equivalent of saying out loud, "I've stolen this," to my case, or your case, where Mr. Minot's act arguably was the same as saying he had possession of human remains. So again, a fact from your case is being compared very precisely to a fact from the precedential case. We'll see a couple more. Here, I'm comparing unzipping the duffel bag, a fact from your case, to, let's go forward a little bit, the act of rolling up one's sleeve, a fact from a precedent. And if we go to the yellow, I'm comparing the question from Ms. Canterbury, why not, a fact from your case, to this question in the precedent about whether the client had a tattoo. There's a couple things to be aware of and to be cautious of when doing the A of IRAC. And the first is to avoid name dropping. Don't just go through the motions of mentioning an authority in the A of IRAC. You really need to make a substantive comparison, again, between the facts of your case and the facts of that precedential case. So mentioning the name of the authority and making no real connection to your case is not enough. Let's see some examples of how this can be done badly and just amount to some name dropping, and how it can be done a little bit better. I'm going to give you the background on this case before we jump into the examples. This was a hypothetical case I gave my students involving two architectural drawings. Both architects had gone to visit the site of an ancient Minoan temple. The temple exists in reality, but of course it's 2,000 years old, so it's a ruin. There's a lot in the historical record, however, about how these temples looked when they were new, and there were certain rules that these ancient architects would follow when they built these temples. And so both architects, the modern architects now, wanted to depict the temple in a drawing, an architectural drawing, as it would have appeared when new. Both visited the site, both knew the history of these temples, and so there were a lot of constraints on if they're both doing their job correctly and making an accurate prediction or rendition of how this temple once looked. There were a lot of constraints on them. They didn't have a lot of discretion. The hypothetical, though, was that the first architect sued the second architect for copyright infringement. Let's see our examples now with that background and see an example of name dropping. Here's an example of name dropping. Unlike Smith, an architectural drawing of a well-preserved Minoan temple does not require much artistic discretion. First of all, the writer is comparing the whole entire case Smith to an architectural drawing. Again, you need to compare apples to apples, drawings to drawings, temples to temples, people to people, maybe cases to cases, but not cases to hear either a temple or a drawing. Let's see how the writer could have done this better. An architectural drawing of a well-preserved Minoan temple does not, in contrast to the abstract painting at issue in Smith, require much artistic discretion. So the writer has mentioned the case Smith, reminded me about Smith, which the writer had detailed for me in the R of IRAC, but has compared an architectural drawing to an abstract painting. And now I get it. There's a lot of discretion when we're doing an abstract painting, and as I said when I sort of set up this slide, not so much discretion when you're trying to draw a Minoan temple as it existed when it was new. So the writer is comparing a drawing to a painting, an architectural image to an abstract image. Let's take a look at another example. And this is a hypothetical I give my students about whether a company can trademark a color, and in particular, whether Procter & Gamble could copyright the color pink in Pepto-Bismol. So we'll see the example of name dropping first. In this case, like manna, other companies produce and sell digestive aids that are the same color as Pepto-Bismol. Again, what the writer's doing here is comparing a whole case manna to, I guess, this concept of other companies producing pink medicines. A better way of saying this would have been the following. There are other companies that sell digestive aids that are the same color as Pepto-Bismol, just as in manna there were other companies that sold cosmetics in black compacts. Now I get it. In manna, it was a product, it was cosmetics, but it was a black product. And that's very similar to my product here. It might be a medicine and not cosmetics, but the medicine is pink. So I see this is a nice substantive comparison between your case and the precedential case. It's not making me as a reader work too hard. It's making the connections, connecting the dots for me, and it is not a fact dump. The first example, we might just call it a fact dump. There are no facts from manna in the first example. Another caution in the A of IRAC is don't restate the rules. There's enough redundancy built into our recipe for a legal memorandum that we don't want to add additional redundancies where they're not necessary. You've already stated the rules in the R of IRAC. You don't want to restate them in the A of IRAC. What you want to strive for is something I call a hybrid sentence. So in avoiding a fact dump, don't let the pendulum swing too far the other way. Don't start repeating your R of IRAC in the A of IRAC. Don't have sentences in the A of IRAC that consist entirely of legal principles. Let's see an example. This example, just to set it up for you, is a Fourth Amendment case. And it has to do with the idea that the Fourth Amendment does not apply outside the geographic boundary of the United States except when the foreign actors are acting as agents of the United States or when American officials participate in this search on foreign soil. In the example we are about to see, the law came from a case called Stonehill, which occurred in the Philippines. And the facts of our case, or of your case, if you're the student writing this memo, the facts of your case happened in France. Your client was Jamie Chaloub. He was searched in France, and it was the NSA that was involved in this search. So let's see an example. This is not badly written, but I want to just point out one thing to you. I'm going to circle the law in blue. That is all law. That whole sentence about Stonehill, that's a precedential case that was discussed in the R of IRAC, and it's being restated here. This part in red, that's all facts. That's all the facts of your case. Again, What you want to do is keep the redundancies to what's strictly necessary, and you want to strive, if possible, for hybrid sentences. So let's take a look at how we would make this into a hybrid sentence. We might say something like this: the French officers did not decide to conduct a search on their own, as the Philippine officers in Stonehill did. I'm circling this in purple because it's got a little bit of blue, our law, and it's got a little bit of red, our fact. So that's what we want. We want this purple. We want this blending of law and facts. Next sentence. They did so at the request of the NSA. Now that's all facts, and you may indeed, in your A of IRAC, have some sentences that are all the facts of your case. That's okay. Let's take a look at the next part. And they did not seek evidence that could be used in a domestic prosecution, like the Philippine agents did in Stonehill. They sought only evidence that could be used in a U.S. prosecution. Again, a blending. I've circled it in purple because it's a blending of facts and law. And these are the sorts of sentences we want to strive for. So hopefully most of your sentences will have this hybrid purple kind of nature. Some of them might be all red. They might be all the facts of your case, but try to keep that to a minimum. And really, really avoid having any sentences that I would circle in blue that would be completely restatements of the law that you stated in the R of IRAC. Everything needs to be stated first in the R. You don't want to spring new facts on the reader in the A of IRAC. You're going to state all the facts first in the facts section, but you also don't want to spring new laws on the reader in the A of IRAC. You want to put all that law up there in the R of IRAC and then weave it in, mention the case names, mention the statutes, weave it in with hybrid sentences as you see here. Thanks again. With that, you have the tools you need to write a very strong A of IRAC. I'll see you next time.